On Tuesday, April 22, 2025, the Post-Courier carried a headline that captured national attention: Government goes to court. Leader of government business, Peter Tsiamalili Jr, announced that the Marape government plans to return to the Supreme Court, seeking an interpretation on whether the court's March 2025 decision breached the Constitution. Specifically, the government questions whether the court's directive to reconvene Parliament and facilitate debate on a motion of no confidence violated Section 99, Separation of Powers between Parliament, the Executive, and the Judiciary, Section 115, Parliamentary Privileges and Procedures, Section 124, Calling of Parliamentary Meetings, Section 134, Non-Justiciability of Parliamentary Proceedings, Section 11, Supremacy of the Constitution over Inconsistent Decisions. Why did the Supreme Court order Parliament to reconvene? The Supreme Court ruled that the Parliamentary Committee's rejection of the opposition's motion of no confidence in November 2024, based on Standing Order 167, was unconstitutional. The court cited breaches of Section 111, Membership and Representation in Parliament, Section 125, Responsibilities of Parliament, Section 142, Executive Government, and Section 145, Motions of no confidence. Exercising its constitutional powers under Sections 18, 19, and 155, the court ordered the Speaker to reconvene Parliament to allow proper debate on the motion of no confidence. Not the comical turn of events. Instead of complying with the court's orders, the Marape government, the Speaker, and Tsiamalili Jr defied them, refusing to facilitate the required debate. Now, astonishingly, they are crawling back to the court asking for constitutional clarification, while publicly accusing the court of overreach and interference. This sequence of actions raises serious concerns. Defy the court first, accuse it of interference, then seek its interpretation? If that's not a case of dumb, dumber, or dumbest, what is? Had Tsiamalili Jr respectfully submitted that the court's decision may conflict with constitutional provisions and sought guidance, the government might have maintained some legal credibility. Instead, grandstanding through the media has only weakened their standing further. Did the Supreme Court overstep its powers? Short answer: no. The Supreme Court has historically intervened when Parliament has failed to meet its constitutional duties, not when mere breaches of standing orders occur. The Marape government clings to an August 2024 case where a poorly argued opposition challenge, focused only on standing orders, was dismissed under Section 134. However, in the latest case, the opposition smartly focused on constitutional breaches, not just standing orders, and the court ruled accordingly. In constitutional matters, the court must intervene if Parliament obstructs fundamental rights, such as the right to move, debate, or vote on a motion of no confidence. The Marape government's real problems: misinterpretation of Section 134. Tsiamalili Jr wrongly claims that standing orders were suppressed. Section 134 only limits judicial review of procedural matters, not constitutional breaches. A defiance of court orders. By refusing to comply, the government has placed itself in direct violation of the Constitution. Potential contempt of court. Their actions could lead to serious legal consequences, including contempt proceedings and even imprisonment for those involved. The risk of an even bigger backfire. While the Marape government asks for constitutional interpretation, the opposition could also raise powerful counter-questions. Did the Speaker, Tsiamalili Jr, and certain ministers conspire to circumvent court orders? Does such action amount to contempt of court? Should they face imprisonment? If these issues are raised, the government may be forced to withdraw its case to avoid even greater embarrassment, or worse, legal penalties. And frankly, based on precedent, the Supreme Court is unlikely to rule in favor of the government. Conclusion: a crisis of constitutional democracy. This isn't just about political pride, it's about public trust in Papua New Guinea's constitutional democracy. The courts operate on the principle that the Constitution is supreme. Unfortunately, many of PNG's political leaders operate under the false belief that Parliament is supreme and that they are above the law. The Marape government is once again making history, but for all the wrong reasons. Dumb, dumber, or dumbest, take your pick. For a government that boasts of leading the richest black Christian nation, its actions are increasingly unchristian, unethical, and unconstitutional. Your children's future matters. Join the fight to save Papua New Guinea's democracy. Comment, share, and stand up for the rule of law.